For judgment, item number 1, OJC 4048 of 1994.
There is no merit in this petition and it is dismissed as such.
Item number 2, WPC 12002 of 2004.
The rejection of the petition's claim by the OSFC is set aside, and a direction is issued to the OSFC to make payment of the unpaid salary for the months of November and December 2003 and the entire salary for the period of suspension from 4th November 2003 till 24th May 2005 for treating it as on duty. And then we've asked for simple interest at 6% to be paid. And if there's a failure to pay it by 11th April, then penal simple interest at 9% per annum should be paid.
For judgment, item number 1, WPC 3192 of 2008.
The writ petition is allowed. A direction is issued to the MCL to provide employment to the petitioner under the rehabilitation scheme.
For judgment, item number 4, WPC 9428 of 2010.
The writ petition is allowed in the above terms. No orders is to pass.
Item number 5, WPC 24808 of 2013.
We've directed the opposite parties to condone the shortfall in the qualifying service and pay the pension from 1st July 2009 onwards. The writ petition is disposed of.
the facts of this case, my lord, is an addition under Section 68 of the Income Tax Act was made, my lords. My humble contention, my lords, a paper book containing the details like the return figures.
Just a minute.
Item number 6.
Here, my lords, before the learned tribunal, I'd filed a paper book containing the returns of the persons who has I had asked, told them that one Mr. Sheikh Tahir had deposited this amount, and to test his credit worthiness, my lord, I have given an affidavit. I've given his returns, my lord. He's a register. He's very much bearing a PAN number with the Income Tax Department. For the relevant assessment year in his returns, my lord, this amount of 15,69,530 was shown, my lords. Then, my lords, pursuant to a questionnaire, he also disclosed the sources of persons to whom he had given money and from whom he had money were due to him, including the telephone numbers, my lords. All these materials, unfortunately, was not considered by the tribunal, my lords. For lordship's prima facie consideration, may I just pass on the paper book, my lords, which was filed before the learned tribunal, my lords. Lordship may kindly peruse the paper book, my lords. I've just flag marked these three portions.
Let's come to para 7 anyway.
7
of the impugned order.
But he says that having carefully, may I place it, my lords?
Yes.
Having carefully examined the orders of the authorities below, in the light of the rival submissions, we find that the undisputedly SSC is a salaried employee, and therefore he is having his bank account at Bhubaneswar. When substantial amount was found to have been deposited in his bank account, SSC was asked to explain. Then it was explained by the SSC that his cash, this cash was deposited by his friend in his account while doing his business. The AO examined the friend of the SSC, Sri Sheikh Tahir, and was of the view that Mr. Tahir could not identify most of the persons from whom he had taken money. According to him, Mr. Tahir did not have any specific business premises. Having carefully examined the statement of Mr. Tahir, the AO was of the view that the explanation of the SSC is not reliable, that cash was deposited by his friend. Before the CIT appeal, except placing a reliance upon the earlier submission, no other evidence was filed. Similar is the case before us. The SSC's main plea is that his bank account were operated by his friend while doing his business. The account was with the bank situated in Bhubaneswar, where the SSC and his friend were staying. It has not been explained as to us as to why the SSC's friend did not open a separate bank account and do his business, and what was the need to use the bank account of the SSC for transacting its business
so
by his
nearly
friend.
15.7 lakhs in cash, right?
What are
you otherwise?
No, I am an employee. I am an employee of the ICICI Bank. My friend, Mr. Tahir.
What are you there?
No, I'm a officer of that particular bank, my lords,
okay,
with the bank account of Bhubaneswar, my lords.
All right.
One Mr. Tahir, my lord, he's a friend of mine, my lord. He had taken availed certain loans, my lord, facility, for which he could not open an account, my lords.
Why?
Lord, he had a difficulty, my lords.
No. So that is where the problem lies, right?
So my humble
in these modern days, a businessman taking loan for business, not able to open a bank account in his own name is just unbelievable.
Your lordship would appreciate, my lords. What my humble contention is that the finding of the tribunal that no evidence was placed is not correct in the fact, because the paper book, if your lordship would kindly peruse the paper book that
this tax also will be paid by that friend.
No, lords, he had, my lord. No, he had, my lord. He is income tax SSC, my lord.
What is
Flag 2, my lord, your lordship means I have just flag marked the relevant portions. My lord.
All right.
Flag 1, my lord, is his
Affidavit. All right.
Flag 2, your lordship may see, my lord.
Right.
This was a return filed for the assessment year, my lords, 8-9, my lords.
Right.
Relating to the relevant assessment year.
Right.
The next, if your lordship would turn over the page, he has declared this amount, my lords. Your lordship may see the second flag, my lords.
Right.
Then if your lordship would see the third flag, questionnaires were put to him, my lords. And in respect of question number 9, if your lordship would see, my lords, he has disclosed names, my lords, with mobile numbers, my lords. And unfortunately, my lord, none of these people, persons were, my lord, summoned, were called for to test the veracity, my lords.
No.
But
The finding is something else. The finding is that he could not recognize any of them.
No, my lords, that is not a fact, my lord. My humble contention, my lords, when I have specifically
He could
given
not
the
identify most of the persons from whom he has taken.
what has happened, my lord, is
Yes.
I have disclosed the names, including the telephone numbers, my lords.
No, that's
And my lord, I am an income tax assessee, my lords.
Yeah.
And for the relevant year, my lord, I have shown this amount in my assessee.
no.
And this is not, my
now
lord,
this I is Tahir.
sorry, my lord. Yeah, Ms. Tahir, my lord.
Uh-huh.
This is Tahir's returns, my lord, is at flag 2, my lords.
Right.
And Tahir, my lord, is an assessee with the PAN number.
Right.
And I have filed for the relevant assessment year 8-9.
This whole story is unbelievable.
See, once, my lord, I have
you're a
disclosed.
bank employee, somebody parking 15.7 lakhs cash in your account is something
No, my limited, my lord,
extraordinary.
my limited prayer before your lordship would be, my lord,
Yes.
let the tribunal apply its mind, my lord, to this fact, my lord.
These are concurrent findings. I'm sorry.
No, it's a concurrent finding, but unfortunately, the observation of the tribunal that no evidence is placed
Yes.
is not borne out from records, my lord.
No. This
Because
whole
this
paperbook
paperbook-
was there before the assessing officer.
No, my lord. So this paperwork was there before the assessing officer.
Ah.
This paperwork was there before the tribunal.
Yes.
My lord, unfortunately, that there's no
All the
discussion.
tribunal is saying is no additional evidence has been placed, which is right.
My lord, what I was humbly praying, my lord,
Yes.
if the particular person, Tahir, is, my lord, is an assessee under the Income Tax Act,
Right.
he has disclosed this amount in his income, my lords. At least that should have been discussed by the tribunal, my lords,
Right.
or the authorities below, my lords.
All right.
So my limited prayer before your lordship would be that if your lordship would
Yes.
my limited prayer before your lordship would be, my lords, time-bound remand to the tribunal to examine, because Tahir is a assessee, income tax assessee, my lords.
Right.
So if he has means, my lord, to show that he had that amount at the relevant point of time, my lords, and he has deposited it, my lords,
Yes.
bona fidely
Yes.
in my account, my lords.
Yes.
This addition in my
Where is
hands,
it bona fide? See, that's a crucial word in this whole case.
bona
How
fide.
can somebody bona fide deposits of 15.7
No,
lakhs? He's a businessman. Why would he pick up a salaried employee of a bank to deposit
They were
15.7
friends.
lakhs?
Your lordship would appreciate the background. They were friends, staying together at
No.
Bhubaneswar. So only to help out a friend, my lord.
What does that help out? Exactly.
But-
That's the whole point. What does that help out?
He was having difficulty
No.
in transacting his business.
No. That's completely unbelievable.
No, at least let the credit worthiness of Tahir be re-examined by the tribunal, my lord,
No.
in face of the paper book, my lords.
No, sorry. The present appeal by the SSC is directed against an order dated 26th May 2015, passed by the Income Tax Appellate Tribunal, Cuttack Bench, Cuttack, bracket IT80, in ITA number 473/CTK/2013, for the assessment year, bracket AY 2008-09. The question considered by the IT80 was whether the assessing officer, bracket A, was justified in treating a deposit of rupees 1569,530 in the bank account of the assessee as income of the assessee, on the ground that the assessee was not able to satisfactorily explain the circumstances of such deposit. Paragraph. The return filed by the SSC was picked up for scrutiny.
One 143.3.
Yeah. On account of various deposits found in the bank account of the SSE, who is an employee of the ICICI Bank, who is a salaried employee of the ICICI Bank, in the aforementioned sum of rupees 15,69,530, the AO made the above addition. Not satisfied with the explanation that the said deposits were made by the SSE's friend, one Mr. Sheikh Tahir, who was doing business. As it transpired, Mr. Tahir also filed his affidavit before the AO, but the AO was not convinced with the explanation furnished. Full stop. In particular, Tahir could not produce documentary evidence of his own business transactions, of receiving a debit card from one Sri Motwani, and the details of persons making deposits in the account of Sri Motwani. Full stop. Interestingly, Tahir did not have any specific business premises. Full stop. He was receiving telephonic orders over phone from various parties. And after receipt of money from parties through the account of Sri Motwani, he was supplying them auto parts through local bus service. Full stop. Importantly, Tahir could not identify most of the persons whose names figured in the bank statement. Consequently, the case of the version of the SSE that Tahir had bona fide parked his money in the SSE's bank account was not believed by the AO. Paragraph. The same paper book containing Tahir's affidavit and other documents, including Tahir's own bank accounts, including Tahir's written statements, were placed before the CITA, who concurred with the AO. Stop. Paragraph. The ITAT has again examined the entire material and concurred with the views of the AO as well as the CITA. Paragraph. The main plank of Mr. R.P. Kerr's learned counsel for the appellant's argument was that Tahir had disclosed the aforementioned sum in his own returns, and this aspect was not examined by the ITAT. Full stop. The court is not impressed with this argument because the burden was on the SSE to give a satisfactory explanation for the purposes of Section 68 of the Income Tax Act 1961. The source of the aforementioned sum of rupees 15.7 lakhs in his own bank account. Full stop. The explanation offered by the SSE was unbelievable on the face of it. Full stop. The attempt by the SSE to produce Tahir, stated to be the source of that amount, was also not satisfactory. Tahir's statement did not inspire confidence. Full stop. Having carefully examined the orders of the AO, the CITA, and the ITAT, this court is not persuaded that any of the said authorities has committed any legal error that gives rise to any substantial question of law that requires to be examined by this court. Consequently, the court declines to frame the question as urged. There is no merit in this appeal. It is dismissed as such.
Much obliged.
I am appearing in this case.
May I take return of the paper book?
Yes.
Item number 7.
May I please?
Yes.
Meanwhile, this IT It is infructuous because he has already opted the Vivasi Vishwas scheme.
All right.
Already paid the tax as
Mr.
per
Patnaik
Vivasi
says
Vishwas
that since the appellant is already availed of the Vishwas, what
Vivasi Vishwas.
Vivad
Vivad se Vishwas.
Vivad se Vishwas scheme, the appeal has been rendered infructuous. It is disposed of as such.
Item number 8.
May I please ask? Lordship, this is a public interest litigation. The second round of litigation and the first PIL, the order was to direct the authority to take a decision. They have taken a decision. It is the annexure 5. Annexure 5. Sir, my lord, the page 78, my lordship, kindly have a glance. That's opened this IMFL offshore where the temple is there and one college is there and the Xavier school is there and care hospital and Adyanta Plus 2 college and the Vaishnavi temple is within 150 meters now.
This order is appealable. Collector's order is there and it is to be appealed before the excise commission.
You can file an appeal, sir.
Yes.
Counsel, the petitioner seeks leave to withdraw this petition with liberty to file the appeal before the excise commissioner in accordance with law. Disposed of is withdrawn with liberty is paid for.
Item number 9.
This is a matter which is covered by a lordship's decision, my lord, because it is here challenged the notice under section 148 under annexure 1, my lord. That is
JT. All right. Who's
Milord,
Mr.
it is
Chimamanda?
assessment of 1516.
similar case, my lord.
No, my lord. It is assessment of 1516 and notice is given within time.
No. Authority giving the approval.
Approval, yes.
Joint CIT. You say in the challenge in the present notice, Mr. Chimaka accepts notice. You say the
Yes,
challenge in the present petition is to the notice under section 148 of the Income Tax Act 1961 on the ground that it was issued after necessary satisfaction, not of the CIT, but of the joint CIT range 1 Cuttack. Clearly, therefore, the jurisdictional requirement under section 148 read with section 151 of the Act is not satisfied. Consequently, the impugn notice is quashed. The petition is disposed of.
It is already, it can display, my lord, your lordship's decision is well covered.
Yeah. It's this decision
I have
is
already enclosed
consistent with the view already taken by the court in its order dated dash in
Annexure 2.
All right.
The lordship annexure to page 15 is totally relevant to this case.
All right.
For orders item number 10.
Lords, I beg to appear in this matter.
Yes, please.
Two questions of law were admitted by an
Yes.
order of 8th February 2016.
Yes.
The first question was on the applicability of section 43B of the Income Tax Act on a payment made by me under the directions of this honorable court as confirmed by the Supreme Court. May I just give a background to this?
Yes, please. Yes. Please.
Dispute arose between me and the state government on the payment of electricity duty as to what will be the rate under which I'll be paying.
Right.
Malad, by an order dated 21st April 2005, which is at page 28 of the paper book, Malad, this honorable court directed that insofar as the duty which is undisputed is concerned, I will pay state to the state government. We'll see page 29.
Correct.
Which is
and the differential amount will be in a non-lien account.
Correct. Because thereafter on, this order got confirmed. In fact, my writ petition got dismissed, challenging the levy of electricity duty by a judgment dated 6th May 2010, which is at page 30 of Manoj's paper book.
Right.
And the operative part, we'll see at page 63. So the entire duty, of course, was due and payable, but also paid.
Right.
Now, I approached the Honorable Supreme Court challenging the final judgment.
Right.
In the interregnum, the Honorable Supreme Court was pleased to direct that this this differential amount will be put in an escrow account. And this is at page 66 of Malod's paperbook.
Right.
Now, the short legal question which arises is whether 43B as it stands, Malod, or as it stood at the relevant time, requires me to pay it to the actual bank account of the
Company,
of the state
electricity
government,
company.
or if I have paid and money has gone out of my control, is that satisfaction of 43B? Now, kindly, Malod, in that regard, have section 43B. And I'll show, Malod, the tribunal has misdirected itself in going on a principle which is not applicable here. I'll show that.
Yes, tell us.
Section 43B, may I read?
Yes, please.
It says, notwithstanding anything contained in any other provisions of this act, a deduction otherwise allowable in respect of A, any sum payable by way of tax, duty, cess, or fee by whatever name called under any law for the time being in force. Malas, this is relevant. And Malas now comes straight after G to the part where it said shall be allowed irrespective of the previous year in which the liability to pay such sum was incurred by the assessee according to the method of accounting, only in the year of computing the income referred to in section 28 of the previous year, in which the sum is actually paid by him. Now, Manoj, this actually paid by him could have two connotations. One, as the tribunal says, actually paid and actually received by the state government. Or it could mean I have actually paid, I have discharged my liability. By orders of court, it is kept in an account. Now, Manoj, with great respect, may I say, the first interpretation which the tribunal has read is reading words into the language, meaning thereby the language of section doesn't say actually received by the state government. It only says actually paid by him.
No, but paid, if it is conditional, the only question is this.
Please, Manoj.
This is a payment in an escrow, meaning that if ultimately you succeed, it will come back to you.
Correct.
So you've not really parted with the money irrevocably.
Manoj, I'll tell Manoj, that is taken care of. Manoj, that is taken care of by section 41(1). If Manoj will have section 41(1), because if the money comes back to me, I get taxed under 41(1). Please see 41(1). And Manoj may bear in mind one more aspect, that I'm a listed company. Manoj, I have to give true and correct picture of my accounts. Now, what happens is if I keep accruing this amount and I don't pay or don't claim deduction, in the year in which the Supreme Court ultimately decides, I will have 100 crore or maybe a 200 crore deduction, which will not reflect my true and correct affairs in that year. Vis-a-vis, if the money comes back, 41(1) gives the right to the tax department to tax that amount. Kindly see 41(1) in that regard, Manoj. Because 41 says, where an allowance or deduction has been made in the assessment for any year in respect of any loss, expenditure, or trading liability incurred by the assessee, and subsequently any previous year, the first mentioned person has obtained, whether in cash or in any other manner whatsoever, any amount in respect of such loss or expenditure or some benefit in respect of trading liability by way of a remission or cessation thereof, the amount obtained by such person or the value accruing to him shall be deemed to be the profits and gains in profession. And
is there any case law?
Manoj, may I come straight to that? Manoj, what has happened in this is, on electricity duty and 43B, there is no case law. There is one decision of the Honorable Gujarat High Court, which seems to have weighed in the minds of the tribunal also. And Manoj, there the facts were, the assessee had only given a bank guarantee. Manoj will see the distinction here is I'm not giving a bank guarantee, I'm actually placing the money in an account. It has gone out of my coffers. And in that regard, Manoj, the Honorable Gujarat High Court has taken the view that since money has not gone out of your coffers, therefore you've only given a security, then 43B kicks in. Manoj, that decision, Manoj, is of the Gujarat High Court in Mugat Dying. And that is, Manoj, cited as 290 ITR 282. In fact, Manoj, in that decisions, if Manoj permit, may I share the screen and show it? If
Yes, yes.
please, Manoj. Manoj, the host will have to allow me to share the screen.
No, no, he will.
Grateful, Manoj.
Screen sharing.
Manoj, that decision, till I'm allowed, that decision in turn follows, Manoj, the celebrated Supreme Court decision in Dunlop, where, Manoj, the Honorable Supreme Court had taken the view that furnishing of a bank guarantee is not actual payment, which, Manoj, there cannot never be a dispute. But in this case, looking at the peculiar facts of this case, money has actually gone out of my coffers. I have no control over the money now.
I think the sharing is allowed.
Yes, Manoj. Let me, Manoj. Manoj can see this.
Trying. Okay.
May I, Manoj, show the facts here, Manoj, in para 1.
Yes.
Both these appeals arise out of an order dated so-and-so passed by the Income Tax Appellate Tribunal for the SSNB so-and-so. The common dispute involved is disallowance of excise duty liabilities for the so-and-so by invocation of Section 43B. Manoj, have that?
But in effect, Mr. Jolly,
Please, Manoj.
that, see, whether you keep it in an escrow account or a no lien account, something that the other side does not have access to. That's what it means. Even in a bank guarantee, they don't get access to the amount till the event that needs to be triggered off for invocation occurs. So they don't have access to that amount. It is still under the control of the court.
Manoj, the question is, does 43B bar disallowance on account of my money going out of my control, or it should be under the control of the government? Manoj, by reading these, it should not be that once I have paid and by a court order, in fact, the court...
So one part is okay, you have parted with money.
Please, Manoj.
But they don't have access to that money because it's in an escrow account.
Please, Manoj, in that regard, kindly see 43B once more with me.
Right. Yes.
The phrase used in 43B at the last Manoj, which I read, was actually paid by him.
So what's happened in the Supreme Court is still pending?
Manoj, it's still pending.
I see.
In fact, a couple of times it got listed in the Honorable Supreme Court.
Okay.
But because of Manoj, the pandemic, this will have to be finally argued physically because the validity of the provision is also in challenge. So that main dispute has not got resolved there.
I see. All right. So you
So,
want to
Manoj,
do 43B again?
Yes, Manoj. 43B, Manoj, the operative phrase in the section, as Manoj saw earlier, is actually paid by him. It is not actually received by the recipient. Manoj, the purpose of this provision was that the taxpayers were accruing liability and not paying. I have paid under the orders of the court. I am out of cash today. And the interests of the revenue are protected.
So are you still asked? Do you still have some thread tied to that cash? Is the question.
No, Manoj. In fact, what is what is this no lien or escrow account, Manoj? Even if the interest accrues there, I don't receive any interest. The bank doesn't pay me any interest. It gets accrued
in that account. No, you don't receive, meaning it gets accrued. If there is interest, it will get accrued.
It gets accrued, and whoever wins ultimately will.
That's right. Gets it.
I have parted possession with the money today.
Right.
I am not accruing any interest on it. If it was in my control, Manoj, I would have got the interest also. Manoj, though, therefore, my respectful submission, Manoj, in this case is these. First of all, there is no dispute between me and the tax department that the liability pertains to this year. That the tribunal also agrees with me.
Right.
Tribunal says by way of a fiction, 43B, although you are following mercantile system of accounting, deduction is otherwise allowable, but by way of a 43B embargo, the deduction is disallowed. Now, 43B, Manoj, will have to be then strictly construed to mean actually paid by him, which means actually paid by me, which is also not in dispute.
Right.
under the orders of this honorable court. I'm out of cash. Now, in that situation where it is the liability has accrued and actually paid by me, the mere fact that under an order of the court, the department is not entitled. In fact, my respectful submission is department could have actually applied to the court and withdrawn with an undertaking that in case they say succeed, they'll pay me back with my interest. But I think the department is also, in that sense, the state government is also unsure on which way the matter will go. Therefore, they never moved those applications. Money has gone out of my coffers. So my respectful submission is it is actually paid by me. And the word actually paid by him is satisfied in this case. Mere fact that the respondent, the state government has not been able to receive the money by an order of court does not mean that my liability has to be disallowed. And Manoj, the other flip side is that I seek to lose everything in this year, whereas if the department, if the Supreme Court were to ultimately decide otherwise, the money will go back and under 41(1), the department can tax me.
No, see, actually, when you say actually paid, there is a payer and the payee, right?
Please, Manoj.
It is not paid to the payee. It is
Please,
paid.
Manoj. It's paid.
So, can we say it's actually paid? The word actually means.
I see what you call
the word paid. So, actually should mean that the payee is received. That's how the word actually should be understood.
Manoj, I would, with great respect, Manoj, may I?
1 minute.
Please, Manoj.
Yes, Mr. Javed.
Please. So, may I respectfully submit, Manoj, this is in the sense of an anti-abuse provision. Because will have to be strictly construed. In that sense,
this is why I'm asking you to reflect on actually, the word actually.
That's why I was coming to. I see what is falling from. Manoj, actually paid, in my respectful submission, would mean the money goes out of the coffers of the taxpayer and he loses control. Now, Manoj, may kindly test it on that principle, because the words the legislature could have used the words actually paid into the account of the recipient or actually till the time actually received. I'm not
actually you've not lost control, because there is some kind of an assurance in the form of that interim order saying that if you succeed, it comes back to you.
No, Manoj, even that is
lost control in that sense.
Manoj, it is not even that. Kindly see the interim order, Manoj. Kindly see the interim order first, Manoj, of 21st April, which is by this honorable court, Manoj.
Correct.
It's page 28.
Right.
It says the money shall be deposited in a no lien account.
Right.
The only interim protection that I get is that no coercive action for recovery will be made after that. Right. It is not that the money is reverted to me or I have a control or right over the money.
Importantly, the other side doesn't get control over it. You see, I think that we are missing that other component of this whole thing.
I see that, Manoj. Therefore, what my lords then, Manoj, then we are reading the section actually paid by him to mean actually paid by him and received by the recipient.
Yes, because payment, the word payment involves two persons, right? Somebody who pays and somebody who receives.
Manoj, it doesn't. Therefore, I'm saying, Manoj, it does not say that it must be paid into the account of so and so.
What
It only-
else? See, the whole section 43B is for
Manoj.
discharging all these liabilities that you have.
Correct, Manoj.
Duty, cess, fee, whatever name called. So where's the question of allowing a deduction for something which has not reached the other person?
Manoj, it's the purpose is not that it should have reached. It should have been that I should have lost control over that, because Manoj, otherwise the liability is
No,
accrued
the
in
word
this year.
actually, I'm actually again emphasizing on the word actually.
If Manoj, if kind of, I see that Manoj could Manoj, in that regard, just see the impugned order for a minute. Because on first principles, the tribunal is with me. Kindly see, Manoj. Manoj, page 22. Manoj, some 8 lines from the bottom.
Yes.
Well, it says the liability to this accrues therefore in the year in which the power has been consumed, and this liability in view of Electricity Act can be named as a statutory liability. Well, this is well settled so far as so and so. Accrual of statutory liability arises in the year of the taxable event, and even though liability may have been disputed by the assessee, the Honorable Supreme Court in Kedarnath Root has laid down the proposition that accrual or arising of liability to pay statutory is when the taxable event takes place, and assessee who follows mercantile is entitled to deduct from profits and gains as accrued during the year. In this regard, existence of entries in books of accounts is not decided, but we note embargo on 43B. Now, Manoj,
the
43B.
reasoning
Sir.
is, no, just come to page 24.
Please, Manoj.
Therefore, in the case of the SSC, we have to see.
Please, Manoj. Because I was showing, just Manoj, we could kindly see page 23, the last line.
Yes.
We have second last line. We have already held assessees entitled for deduction in respect of electricity duty as per demand raised by the set. So there is liability as accrued, it is allowable.
Yes, yes.
Now comes in 43B whether you've actually paid. Now, in that light, Manoj, may I read from the paragraph where it says therefore?
Yes.
In the case of assessee, we have to see whether assessee is hit by the restriction of 43B. As is evident from the said provision, assessee will be allowed deduction in respect of electricity duty if the said duty is actually being paid by him during the impugned year or before filing the return in the due date. It is not the claim of the assessee that electricity duty are not duty or cess and 43B is not applicable. The contention of the assessee is that since the assessee has deposited the amount in a no lien account as per directions of the Honorable High Court, the depositing of the amount in no lien amount would amount to actual payment made by the assessee. We do not agree with this submission. The words used are actually paid. By depositing the money in a designated account, in it cannot be said the actually has been paid to the state government. Manoj, this is where I beg to disagree with the Honorable Tribunal, because the now it is supplying words to a statute which are not there. The word payment to the state government is not there. It only says actually paid by him. It does not say actually paid to the state government or the responsible authority. The whole purpose of Manoj 43B, may I, in that sense, Manoj, take Manoj a little back, was that if you have lost control over the money you have paid, which is an otherwise accrued liability, then as per mercantile system, you will be allowed deduction. It is only in cases where you keep holding on to the money. In fact, Manoj, this Mugat dying in Gujarat High Court, which seems to be a weighed in the minds of the tribunal, although the tribunal doesn't refer to it, was a case where the taxpayer was holding on to the excise duty in his own pocket. He never paid. He instead issued a bank guarantee and said, let this be discharge of a liability. Because that is completely different from me when I pay at the direction of the Honorable High Court. Because I can't disobey the Honorable High Court's direction. I have to pay. Now, what are the consequences? Then I lose deduction under 43B, whereas the tax department doesn't lose anything because they get everything back under 41(1). So therefore, Manoj, my respectful submission is harmonious construction of 43B with 41(1), which are not at dispute with each other in that sense, or not contrary to each other, would be that in the year where I've actually paid as per the directions of the Honorable High Court, in the peculiar facts of this case, the deduction has to be allowed with a caveat and with a restriction that if the money comes back to me, if I ultimately succeed, the department will have a right to tax this under 41(1). And that also falls well, Manoj, because like I said, Manoj, I'm a listed company. It doesn't then reflect true and correct picture of my accounts.
All right. Go on to the next question now.
Manoj, the next question is, just see, Manoj, the tribunal's finding on this. In fact, they are inherently contrary. Therefore, Manoj, when the question was admitted, this was noted. Manoj, could you kindly just see one page? Page 26. Para 3.3.
Yes.
Now, this is in respect of foreign travel of directors. We have considered the submissions and carefully considered the same. In our opinion, the onus is on the assessee to prove the genuineness of expense. From the details, copy of which are placed before us, we have noted assessee has submitted merely names, places, purpose, and expenditure incurred at that place. Because everything is given. These do not, in our prove genuineness of the expenditure. With great respect, the only thing left is now to take assessing officer with me on all trips to show what I'm doing. I have given the name, places, purpose, expenditure incurred.
How do you know you're not going on a... This is a business tour. That's what you're claiming. It is a business expenditure.
Yes, he says, I've given the purpose also. He doesn't doubt the purpose.
No, where is purpose? Where is purpose?
Just see, Manoj. Just see.
Explore potential market of ferroalloys consumers.
Please, Manoj. And in that light, Manoj, I'll show a decision of the Honorable Delhi High Court in this regard on foreign travel itself. But Manoj, may I just see in the findings of the tribunal, it says the assessee has merely submitted names of directors, places, and purpose of the visit, and the expenditure incurred at that place. Well, what else do I need to prove?
No. Again, show us some case law, because what he says is you've just given the department names of the directors and the places they visit. You've not given the tour itinerary nor the item-wise expenses. That is breaking up as travel, stay, entertainment, and all that.
Well,
is that so unreasonable for the department to ask?
Well, it's not unreasonable, but Manoj, what the finding today before Manoj is that I've given the purpose. Now, what exactly I did, and that's why I wanted to show Manoj that level of detailing where I go and explore.
No. Tour itinerary. For instance,
please, Manoj.
Do you have business meetings?
Please, Manoj.
Something like that. I'm just saying we don't know exactly, but something that should convince the department that, listen, you went on a business tour and not on a...
Well, he's not doubting. He's not doubting that this is for business. All he's saying is some element of personal.
He is doubting. He says if your business, if this was for business purpose, give me some tour itinerary.
No, Manoj,
or give me the breakup of expenses.
Manoj, I'm coming to that. Manoj. Breakup. What is happening in these cases is he's saying that you have incurred X amount of expense. I'm disallowing ad hoc 20%.
And also he's only disallowed 20%. Is that unreasonable? He's not disallowed the entire thing. He says, let us keep aside.
I'll leave it at that, Manoj.
80% is allowed. He's only 20% is allowed.
That could go either ways with on a lighter side.
Yeah.
If he agrees that the trip was for business purposes, then the 20% should not. But Manoj, I'll leave it at that. I'm not going to press that forward.
Correct. All right. Yes, who's Mr. Satpathy? Yes.
Not that fact is not the authority is binding on the section itself. You cannot go beyond the 43B.
That's what he's also saying.
Yes.
He's saying, let us read the section for what it is and don't read into it something which is not there.
Yes. Therefore, we not actually paid. But the fact remains, he has deposited in a conditional.
No, he is actually paid. How do you say he's not actually paid? He does not have the money with him. He's actually paid.
He has deposited in the bank, but it's not. It was not.
He's parted with it.
But he has not deposit. Yes, the word is deposit.
Yes,
deposit in the bank.
No, the word is not deposit. No, the word is actually paid.
Actually paid. He has not actually paid. Lord.
Why not?
Because it was not deducted, but he has not paid the dues to the state government.
No, that's why he's saying don't read into the section with something.
Because
you only asked me to pay, I have paid.
No, because
you did not say pay to him, pay to her, pay to this person, that person.
But it is a duty he has to pay the actual payment. Otherwise, deduction cannot be available because 43 is very clear.
What?
And 43B, Lord, if I will read again, the authority cannot go beyond that because he cannot travel beyond that. He has to go by this wording and the line, Lord. He cannot go beyond that. And again, I'm saying.
No, let's read. Let's read.
Sorry, Lord.
No, let's read.
Yes. Lord, 43B, notwithstanding anything contained in any other provision of this Act, a deduction otherwise allowable under this Act in respect, we are leave it all, then last, Lord, shall be allowed, irrespective of the previous year, who is a liability to pay such sum was incurred by the assessee according to the method of accounting regularly employed by him. He is a mercantile system accounting, Lord. He is following. Only in computing the income referred in section 28 of the previous year, which sum is actually paid by him.
Yes.
He has not paid to the government, actually paid, he has discharged liability for payment of electricity duty to the government.
No, where does it say? See, from his point of view, he's actually paid it. Where does it say? This is the question he's posing.
But suppose, Millard.
This is the question he's posing. He says, from my point of view, they told me don't have it in your pocket. It comes out of your pocket.
Yes.
So he says, I have actually paid it.
No, but
it's come out of my pocket. I don't have control over it now.
No, suppose, Millard, he is winning the case, Millard. Ultimately, the amount.
So he says then 41-1. No. He says, you got your clause into me anyway. Either you take it out now or you'll take it out later.
But
whenever it comes back to me, you'll invoke 41-1 and you tax me that year.
But fundamentally, his accounting standard is wrong. He has in the account, he has taken in the profit and loss and that is paid. But he could have reflected.
No, in fact, it's the correct way of accounting, he says. In fact, he says it will give a distorted picture if I do not show it as a deduction. Because how do I treat it?
But so far as tribunal is,
he says if you want a true and correct picture of the accounts, since I have parted with this money, it should be shown as a deduction in this very year. He says only for the honesty of the accounts was this 43 be introduced at all.
But the tribunal is considering all these things, and I stand by the order of the tribunal.
Obviously, you would stand by.
No, I am actually come across one judgment where the said there's a bank guarantee.
See, tax statute strict
interpretation. That has not been disputed.
No equity.
Still and again, therefore, the authority is bound by their section 43. And so far as the department and the tribunal, state that is not coming within the ambit of the section 43B because he has not actually paid. So far as the state government, he has deported the no lien account. And therefore, the reason and the reason order has been passed by tribunal page 24 from therefore till considering the judgment of the other high courts, I think the question should be answered in favor of the revenue, because he has deposited amount in loan account. It's not actually paid. The word is deposited and the actual paid has to be considered by lordship.
Your last shot.
Please, Malod. Malod, the only short rebuttal I want to make, Malod, was that in terms of accounting, otherwise I'm allowed deduction. The tribunal is with me on that, barring 43B. The tribunal categorically records this is an expenditure which is liable for deduction in this year, barring 43B. So therefore, there is no dispute. My learned friend to that extent is wrong that the tribunal has said this is not an expenditure for this year.
So even for your accounts purposes, Mr. Jolly.
Please, Manoj.
You will still show that you've parted with this money in your accounts also. You'll say you have placed it in an Olean account. So there is no distortion of your accounts that way.
Absolutely. and it is otherwise allowable, because 43B Malos only kicks in if the expenditure is otherwise allowable. If it is otherwise not allowable, 43B.
So how you should treat it for tax purposes may not be identical with how you treat it for accounting purposes.
Correct. That I'm not disputing. But is 43B the word actually paid by him?
Right.
Attracted here where I have parted with the money.
Right.
And there is on this proposition, Manoj, in the peculiar facts of this case, Manoj, there are facts and facts. In the peculiar facts of this case, where under the orders of the court, I have deposited the money, can it be said I have not paid the money? That's the Manoj long and short of my submission. According to me, I have paid the money as per directions of the court, whether it's to a known lien account or escrow account, or the court could have also directed me to pay to the state government. Manoj, it could be anything. Point is, today I have paid, I have obeyed with the orders of the court, and I should not be put to a strict test in that sense of application of an anti-abuse provision, Manoj, where there is no abuse of the law.
All right. Okay, so this is we are answering both questions against the SSC. All right, the appeal is dismissed. We'll pass the detailed order.
I'm grateful, Manoj.
All right.
Item number 11.
So in this matter, the petitioner has already availed for this Vivad Se Vishwas scheme.
The appellant is stated to have already availed the Vivad Se Vishwas scheme. The appeal is accordingly disposed of as instructions.
Briefly, okay.
I'm appealing this.
Item number 12.
I prefer 2 weeks to file IA for a limitation on the ground of a limitation. My lord, there is 4 days delay is there.
How many days delay?
The due date was 17/9/2015. About it was filed on 21/9/2015.
That's okay. It's a very small thing. Now tell us what the matter is about.
Instruction, my lord. The only point is that there is difference of amount, and before the tribunal is submitted that the balance amount was shown in the HUF form and the assessee form and HUF. That was the dispute, my lord.
Yes. Concurrent findings, sir. Concurrent findings.
Para 4, my lord.
Yes.
We have had the contention and gone through the orders of the tax authority below. Before us, the assessee took the same plea that the amount belongs to Mr. Bansidhar Dwarikadas, HUF. In our opinion, the commission is to be given to a person for rendering professional service, and HUF cannot render the professional service.
Correct.
Well, HUF can do business, my lord. The Korta is the
professional service is different, sir.
Well, it's the business. Then C&F issue is C&F agency.
Yeah.
SEC cement, my lord.
Right.
So HF Korta can do business through HF. So that's properly not decision. The decision is not proper in the facts of the case.
The TDS was issued in the name of the firm, sir, not in the name of the HUF. All right. This is this appeal by the SSC is directed against an order dated 3rd March 2015, passed by the Income Tax Appellate Tribunal, Cuttack Bench, Cuttack Bracket IT80, in ITA number 5551/CTK/2013 for the assessment year 2007-8. The ground urged by the SSC concerns the addition made by the assessing officer of a sum of rupees 65,96,562 of an addition of rupees 18,85,497 as commission income. Paragraph. The assessee is the partnership firm, and it contended that the aforesaid sum belonged to the Messrs. Bansidhar Dwarikadas bracket HUF, and that it had wrongly been shown in the name of the SSC firm by Messrs. ACC Limited that the TDS certificate had also been wrongly issued in the name of the firm. Paragraph. Apart from the fact that the finding in this regard against the SSC has been concurred with by the Commissioner of Income Tax Appeals as well as the ITAT. The fact remains that the amount was paid for rendering professional services. Full stop. It is unlikely that TDS certificate would have been wrongly issued by Messrs. ACC Limited. It is plain that it is the firm that provided the professional services and not the HUF. Consequently, this court is not inclined to admit the appeal on the question urged before the court. No substantial question of law arises. The appeal is dismissed.
Well, I am appealing the department.
All right. All right.
Item number 13.
Please, Your Lordship. Here, Your Lordship, defect is translation copy of Odia annexure, Your Lordship. Your Lordship may be taken up next week in the meantime.
No. Just tell us what the matter is about. This is already a very old matter, sir. 2016 matter. Yes,
my lord. Matter, Your Lordship, correction of ROR in the Sabik ROR, the plot that is.
But there are other statutory remedies for these things. No need for a PIL on these things.
There is other remedies under the Sovereign Settlement Act.
For the kind of relief sought about correction of record of rights, there are sufficient remedies available under the statutes in question. Full stop. There is no need to entertain a PIL for that purpose. Full stop. Accordingly, the petition is disposed of, leaving it open to the petitioners to avail other statutory remedies in accordance with it.
Item number 14.
May I please, my lord, there is delay of 35 days.
It's all right. Tell us what the matter is about.
Matter is, my lord, the department is challenging the order of the law tribunal. The ground, my lord, is that 10 crores and 5 lakhs, my lord, were found in the balance sheet. My lord, that was my lord added. But on appeal, my lord, that was the CIT appeal disbelieved on the ground, my lord. That was not credited to the account of the assessee, my lord. And the loan tribunal also, my lord, upheld this year. But our fact remains, my lord, let's say glance to paragraph 5. My lord, the only one account out of the 27 accounts were verified and upon remand report. My lord, there only one account was verified. And the other accounts, my lord, of the assessee company was not verified, where it was erroneously hold, my lord. The amount has not been found credited in that.
No. So this remand report actually showed no amount came to the SSC. The amount from Idea Cellular Limited was a check in hand, which was later returned without being encashed.
Yes, my lord.
So this is all factual, sir. There's no substantial question of law here. You say the present appeal by the department is against the order dated 30th October 2015 of the Income Tax Appellate Tribunal, Cuttack Bench, Cuttack, ITAT, in ITA number 375/CTK/2013 for the assessment year 2009-10. Paragraph. The question sought to be urged by the department is whether the CITA and the ITAT were right in deleting the addition made by the assessing officer bracket AO in relation to the amount for which it was given a check pertaining to share application money by Idea Cellular Private Limited. Question mark. Paragraph. It appears that in the appeal filed by the SSC, the CIT bracket A called for a remand report from the AO on the materials placed before the CIT bracket A by the SSC. Actually, it was found by the AO while sending the remand report that The amount from Idea Cellular Private Limited, open quotation, was a check in hand, which was later returned back without being encashed. Stop unquote. This led the CITA to conclude that, open quotation, since no money was admittedly received by the appellant during the year, there cannot be any addition under section 68. Because what was apparently received was a check only, which was returned. Unquote. There was sufficient explanation offered for the other credits in the account of the SSC. Paragraph. The ITAT has declined to interfere with the above factual findings of the CITA. Paragraph. Having heard learned counsel for the department, the court is not satisfied that there is any legal error in the orders of either the CITA or the ITAT that requires any question to be framed, any substantial question of law to be framed. Full stop. There is no merit in this appeal and it is dismissed as such.
Item number 15. Item 15.
None appears. Dismissed. Not. Item 16. No.
16.
None appears. Dismissed. Not.
Item 17.
None appears. Dismissed. Not.
Item number 18.
Your Lordship,
148.
127, my lord.
127.
I am there requesting the transfer which they have made to Jabalpur in view of the shots are taken.
127. I see.
Please, transfer of the files. My humble submission is that in both the cases,
Sir,
18 and 19,
Jabalpur is not so far away, sir.
but there is no frequent journey to that place, 650 kilometers.
That's all right. Today, all this is not big deal, sir. These days.
Only prayer is that let the matter be taken up here through their officer or by virtual hearing also, because nowadays that
Virtual hearing, we can make a request. Now, everywhere virtual hearing is permissible, sir. So you make a request, no problem. I permit you to make a request. The petitioner is resisting the orders oblique notices issued under section 127. The order dated 25th August 2021 and passed under section 127 bracket 2 of the Income Tax Act 1961, transferring the centralizing the cases of the SSCs, including the petitioners, with the DCIT oblique ACIT Central Jabalpur. Full stop. The only ground urged is that Jabalpur is more than 650 kilometers away from Cuttack. From Sambalpur, and therefore not accessible, not easily accessible for the present petitioners. Mr. Pandal and its senior counsel, the petitioner, is candid that in the present day, with ITAT also conducting its proceedings, with the income tax authorities already also conducting their proceedings in virtual mode, there should be no difficulty in the SSCs appearing before the said authorities. Paragraph. The court permits the SSCs, public petitioners, to request the authorities for virtual hearings wherever possible to tide over any difficulty they may have. Consequently, the court is not persuaded to interfere in the matter. The petition is disposed of.
My lord, I am appealing both the cases.
All right, sir.
Item 19.
Same.
Same, my lord.
Same.
Item number 20.
Yeah, the office note has been perused. The order shall stand corrected as indicated.
Item number 21.
My lord, item number 21, state is the appellant against the judgment of a single judge, honorable single judge, allowing registration of a cell deed in respect of a RIA, which is recorded in favor of the state government and within Sweetwater zone of Puri district. And as per the government notification, there is a prohibition for registration of
anyone is appearing on the other side? No.
Mr. Mishra is appearing for the
instruction. I was appearing in the
he was
court
appearing before the honorable single. I am serving a copy to him.
Let him serve a copy.
Your Lordship may admit it, and another contempt petition is there that is also tagged.
No, that is fixed to 14. Your Lordship can appreciate.
Today. Just a minute. It is there along with this appeal. The contempt petition is also
contempt before the honorable single judge. It is not there. If you will see the order sheet, it is
I
fixed to
know.
14.
I know it is before the single
Don't
judge,
mislead.
but now
Your
it is
lordship
district-
kindly appreciate one thing. There is some development in the meantime. Registration is over. I am holding the EC also. They have taken around 68 lakhs from me towards the registration fee and other thing. It is impounded. Time to time I was asked to pay money. I have been paying, my lord. And now he has withheld the document for nothing, my lord. There are repeated three judgments of this court which says that once a document is registered, the registering authority becomes functions officer to withhold the document. Your lordship, this is not a judgment of this court, my lord. In fact, the judgment is passed pursuant to this constitution bench judgment of the Supreme Court, where it was held that it is my royalty land. The royalty land cannot be taken away. It was taken away by way back in 1953. It was held illegal. Subsequently, because my vendor were staying outside Orissa, they retained the
Your
property in
lordship may
their
kindly
record.
see, the petitioner was the buyer. He is the buyer. The person who has presented this held deed for registration, the vendor, is not coming to court. He is in Kolkata and his identity is in dispute. He is coming on the basis of a
Your
fraud. There
lordship, kindly
is
see
a
that.
fraud. That is also I will submit before your lordship at the time of hearing of the appeal. The persons who are allegedly the owner of the property, they are not in scene. They are in Kolkata and one power of attorney is produced which is found to be defective. And if he says that already this registration is completed, then I humbly pray that status quo as on today may be maintained, the appeal be admitted and the hearing may be, and any order may be passed directing him not to proceed with the contempt petition.
How can it be? Right is accurate person to your lordship, kindly see the
If appeal will be admitted and this registration this deed will be handed over to him, then it will become infructuous. That is my responsibility.
He doesn't
There
have
are
any right.
several grounds.
Your lordship, kindly see. What is the
There
right?
is a restriction so far as Sweetwater zone is concerned. That notification was before this court. There is your lordship may kindly.
Sweetwater zone.
Beg your pardon.
This is in that Sweetwater zone.
Yes, my lord. Sweetwater zone.
No. What happened, my lord? Let me clarify this, my lord. Sweetwater zone is earmarked in respect of government property. My property
It is a government
was
property.
declared in.
It is recorded in government khata.
Maybe.
It is
That
for last
record-
1987, and your lordship will be kind enough to know that in 1987 settlement recorded this land in favor of the state government. He has his vendor, not he is nothing. His vendor who has presented this held deed for registration, he has filed a RP case before the learned commissioner for correction of the record of right. That is pending. So he himself admits that my title is on sub judice before the learned commissioner in a RP case for correction of record of right. At this stage, how the registration can be allowed in respect of a government land which is recorded for more than 40 years in favor of the government, which is Sweetwater zone.
Let him serve a copy.
Yes, I will
let
serve.
me go through it. Your lordship, in the meantime, development is registration is over.
That is not my instruction. My instruction is that registration is not
that
over.
amounts to suppression. How can you? This is the government.
Accepts notice on behalf of the contesting respondent. Do we
Right
need
now, I
to-
am serving.
Do we need to issue notice to the pro forma respondents?
Yes, they are the
Notice
main
will now issue
persons.
to the pro forma respondents, returnable on the next date by registered speed post. The tracking report be placed in record. You say till the next date of hearing, status quo shall be maintained as regards the property in question. The further proceedings in contempt case number 1166 of 2022 shall remain state. List on 9th May.
Obliged.
All right.
But I have not been served the copy. Let him serve. Your lordship take up this matter next week. I don't know. He is suppressing this particular vital fact, my lord. I am giving the government records. Government records. Don't throw it. Sorry.
I am
You are
sending
very
it.
senior to me.
Arre,
Don't throw in like
sending
this.
it.
You know that I was appearing. You didn't serve it.
how can I know that you will also appear in appeal?
All right.
Item number 22.
We have filed our objection to the.
This is a very disturbing factor. After your lordship passed the order to maintain utmost impartiality and safety security of the persons who come to depose before the committee, they have arrested the persons who are deposed before the committee against the police atrocity. For a moment, your lordship may see the report. I have submitted a report what the person stated. they have targeted some persons, my lord. The report, Manas Vardhan said, report page 6 of my report, paragraph 11. This man said that after the severe assault by the police some days ago, they left the village and were hiding themselves in jungle 40 kilometers away. And only today, they have come to the village after the year.
No, Mr. Jena, as far as these people have been arrested, you have to move for bail or whatever you have to do.
Well, that's.
Do you have the names of others who you think would want to depose before the committee and who are afraid of coming? Who are those?
My lord, they will come because those persons who are vocal, who are expected to come, my lord, they have been threatened. Even yesterday
Give
night.
us names, sir.
My lord, he has given
We
5
will
names.
note down the names in the orders and we'll say that they will be
My lord, he has
given
given
enough
5 names,
protection
and
so
I
that
have
they
given
depose before the
explanation.
panel.
I have given explanation to his allegations. That is in para 3 of my counter
Let me
affidavit. Your
complete.
Lordship.
Let me
Yes,
complete.
okay, sorry.
What I say, my lord. Now, here the allegation is people have made allegation against the SP and as well as the IC. That is the disturbing factor.
All right.
Lordship last time directed
No,
the SP.
in these proceedings, Mr. Jena, all we are saying is these two persons,
Well,
para 7 of your application,
yes,
you have mentioned 5 villages, right?
yes, yes, ma'am.
And then 2 of them have now been arrested.
Yes, yes.
Those 2, you will anyway be moving for their bail and all that.
That's a different thing.
That's a separate proceeding.
Right.
What I'm saying is let us not mix up that with this for present moment.
Right.
Your apprehension is there are others who want to depose,
Yes.
who are afraid of coming forward because they may also get arrested. This is your
Yes,
fear.
yes, ma'am.
Those names, if you have,
I don't have right now. I don't have because from ground level, probably.
no. Then how does one address the issue? If you do not have the names of persons who you think want to depose and are afraid to come, how do we then pass even orders?
But there are, to my information, my lord, the villagers, a section of the villagers, my lord, I cannot name right now, my lord. They say that they apprehend.
No, how do we pass, Mr. Jena? The question is this: how do we pass orders? How do we know who these people are, and how do we therefore pass orders saying that they should not be disturbed and they should be given protection to ensure that they come and depose? We can pass a positive order if you give us names. If you're not going to be able to give us names, you can't pass orders then.
No, I'll give names, my lord, but time is required. Right now, I cannot give names.
Then what happens? See, this even earlier, if you remember the very first, second order or third order,
Yes.
I permitted you to give names of all such persons to Mr. Monty.
No, I give you.
It is their part of the order.
You know, that is your lordship has directed that the persons who want to come back to the village.
Correct.
Submit. I have already.
No. So, are there some more persons who are still outside the village?
Yes.
Who want to come to depose? You give them, give Mr. Monty the names.
No, that I will give, Lord. That I will give. But the persons who will appear before the committee tomorrow, my lord, those names I have not collected, my lord. Because they were in a state of.
No. Despite the court passing these orders, despite you being there, if they're still afraid, then they're afraid. I mean, there's a limit to how much we can pass orders.
No, that part I understand. Lord.
They should be conscious that when a matter is pending before court, the whole idea is, and we are videographing the whole thing. If they're still afraid to speak, then there's nothing that we can do.
Last time the committee members were there, the court order was there. Before the committee members, a group came in presence of the police. They asserted
which is why the order has been passed. Which is why we have said again hold the hearing.
Yes.
Which is why we have said videograph this whole thing.
And
What more can be done? Yes. I don't understand. See, there's only so much all of us can give an assurance. If beyond that people are scared, then that's it. They're scared.
But my prayer, your lordship may see my eye. I have a limited prayer. They will come out of the house. They apprehend. Assault by the other group or the police. That must be assured the persons who are interested to depose before the committee.
How do we know? You give us names. Again, I'm telling you, Mr. Jena, without names, it will not be possible for us to pass orders. And those orders can't be implemented. Then again, disputed question will be, this is the person who you intended, but this is the person who got attacked. All that will start. If you're not clear about whom you're talking, then there's a problem here.
Those names, my lord, if possible, I'll provide to my learned friend tomorrow morning or that. If I get it, my lord, I cannot assure, but I'll try my best to collect the names.
Mr. Jaina states that he will try his best to collect names of persons in the village and those perhaps outside the village who are desirous of deposing before the panel of advocates tomorrow. Come on, to Mr. D.K. Manti, learned AGA, by 9 a.m. tomorrow. Full stop.
But will be by that time, we must have left Cuttack. We have to reach there by time.
Mr. Jaina, you find a practical way, because this is no way of.
My lord, it is with my humble submission. This is an impractical approach, because why I am saying this? A, B, C, D, he will send names through my WhatsApp. Then I will say that A, B, C, D are willing to come. Then how it will be organized? The SP will go and take them to the.
No, they will have to assemble in a place. They'll have to come to a place where the police are.
No,
and they will escort them. From
your
that
lordship
place.
has categorically asked us in the previous order to ensure that it is to be held in a peaceful manner.
Correct.
That covers everything.
Correct.
That is what my response. So that covers everything. We have been directed that the meeting should be held in a very, very peaceful manner, and all participants who are interested to come, they should be allowed to give free access to the meeting. And that we are ensuring that my learned friend knows it. And if he says that still some people are apprehending, what is the basis of their apprehension? That is my response.
What is wrong if I provide names of some persons?
No, you
who need
provide.
that
I don't
security?
say that you don't provide. I am not quarreling with my learned friend. But my responsible submission, we have to come to a practical solution. If they provide me, then how he is providing A, B, C, D, then where those people are there, police will find out them, and then police will escort them to the meeting place. These are all things, because he will give me names tomorrow at 9 a.m. We will be starting what we have conjointly decided that 10:30 will start the meeting. So these are the things that what your lordship will direct will comply.
I think by this evening you'll have to give it to him. You give it to him by at least 8 p.m. this evening. Then those persons can come to an identified place from where they can be escorted.
Yes.
My lord, I'll try
by
to,
8 p.m. today.
I'll try to collect the names.
Full stop. If such names are provided, come on, it will be mutually, the place where they should assemble will be mutually decided by the.
Yes, ma'am. But may I put one question, if your lordship will allow me? He is providing, let us assume that some names who are directly involved in other cases which are pending against them, then what we will do?
No, at least till they depose, don't do anything to them.
Okay.
Let them depose.
It's okay. Till they attend the meeting and participate in the meeting, we will not take any. Even if they are accused in other
Even
cases.
otherwise, there are so many. Every time you don't have to arrest persons. You have to only ensure that they cooperate in your inquiry and investigation.
Okay, we accept your lordship's status. Yes.
Say by 8 p.m. and also full stop in that such event, the panel advocates will decide the place where such persons will assemble, the place and time where such persons will assemble, from where they can be given police escort to come and attend the meeting, to depose.
And that should be nearer to the meeting place.
That you decide, that amongst yourselves.
Yes.
That's in Dinkia. Order is clear.
Yes,
in Dinkia. Last time.
Dinkia GP office is the venue.
Not GP.
Then where?
Wherever you arrange. In village Dinkia.
No,
wherever
village
you arrange.
Dinkia GP office we have arranged. Gram Panchayat office, that is the venue, because that is undisputed. Because Sarpanch is going to be the president, the chairman of the meeting. He will conduct the meeting. We will all be the. So your lordship has directed the Sarpanch to remain present. So he will remain present. In GP office, the meeting will be held. I have already intimated to my learned friend.
All right. No further directions are called for. The application is disposed of. All right.
Item number 23.
My lord, this is a public interest litigation matter, my lord. And the petitioner is challenging the public notice dated 4/1/2022 of Appeal Party number 3. That is the collector Jajpur, my lord, wherein the state government intends to grant exclusive privilege of IMFL on SOP.
Your representation has been delivered or not?
Yes, my lord.
Where is that?
That is Annexure 2.
What is that to show it was delivered?
The petitioner along with the villager vehemently objected.
What is there to show you actually delivered? Have you understood the question? Have you understood the question?
Representation has been made or not?
Has representation been, sir, I'm using the word delivered. Have you understood the word delivered? Do you understand the word delivered,
Yes,
sir?
yes, my lord.
What does delivered mean?
Whether they have taken decision or not.
No. Whether they have received.
Received. Yes.
What is that to show the receipt?
Acknowledgement. And there is no acknowledgement of this. But there is a representation annexed 2 at page.
No, there's no acknowledgement of that representation.
My lord, that is received. Annexure 2, my lord, page 14.
I don't, you ask him because I don't think.
They received on 17/1/2020.
Annexure 2 is your representation, but there is no
That is the
endorsement
representation.
on the
Our
representation that
representation-
it has been received by the collectorate.
No,
There is no proof to show that it has been received by the collectorate.
My lord, keep it to tomorrow. I will.
You just make another, this time when you
Yes,
give a
make
representation, make sure that you get an acknowledgement. All right. Have you been to a government office? You've been to a government office?
Yes.
No. What happens when you give a paper in a government office? Are you aware? No.
They received it by putting seal and.
And they'll put a number, a diary number will be there with that seal. All right. Counsel for the petitioner seeks leave to withdraw this petition, liberty to make a fresh representation, and after following up on such representation to seek appropriate remedies in accordance.
Item number 24.
We will file fresh objection and that they will consider it. In
Yes.
that light, my lord.
Item 24.
May please your lordship. My lord, this is a writ petition in the nature of PIL, my lord, and representation was given by the petitioner and the other villagers to the collector Keunjhar, my lord, that with a grievance that there was a cooperative society in their panchayat which has been shifted to another new Maregaon panchayat, which is about approximately distance of 8 to 9 kilometers. At annexure 1, my lord.
No. What is it?
This is there was a cooperative society under their panchayat.
Yeah,
my
what 9 kilometers is nothing, sir, these days.
That has been already given effect to.
Yeah. You see the shifting of the cooperative society has already taken place. The distance is 9 kilometers, which is not considered so considerable for this court to interfere in the present PIL. The petition is dismissed.
Item 25.
May I please your lordship? Lordship, defect number 6 already removed. Copy served to my learned seniors, your lordships. Lordships, in the present petition of petitioner challenging to notice issued under section 148 of the Income Tax Act 1961, your lordships. Lordships, the
Same 7th March.
Yes.
Yes. List on Monday.
Item 26.
Please, your lords. My lord, before coming to merit of the case, just the petitioner is an apex cooperative society, my lord, was providing loan to the rural farmers through primary cooperative societies. Orissa State Coop.
Why have you stopped? Why have you stopped?
No, just your lordship will find it out or not. Orissa primary, through primary cooperative societies, the loan which they gave to the farmers was refinanced by the NABARD. Your lordship, what happened? petitioner, due to heavy incurring loss, most of the staffs have left the organizations. Petitioner's assessment was completed for the assessment year 2018-19 on 26/4/2000 under Annexure 1.
Given 14 installments, sir. 15 installments.
My lord, I came to your lordship's. My lordship, what happened? The entire business has been stopped. The NABARD has stopped the refinancing to the petitioner, and the petitioner is unable to sustain the day-to-day expenses. My lord, what happened? The appeal is admitted. If your lordship direct the appellate authority to dispose the appeal within a period of 1 month, the entire demand may be stayed or kept in abeyance till the disposal of the appeal under section 220 subsection 6 of the Act.
What amount do you have with you? What is the amount in your bank account?
I have got the balance sheet, my lord.
You tell us, sir. You are one learned counsel. You tell us what is the balance in your account.
Chartered accountant has come.
You just tell us the balance in your account.
My bank account is not in disposal. It is a sinking fund. It is a reserve fund. It is redeemed. It has to be redeemed. Under the Cooperative Society Act, certain statutory deposits have been deposited. It has to be redeemed. If your lordship direct the appellate authority to dispose the appeal within a...
You're not answering the question. You're going on the final order that we should pass. You're repeating. All right.
Oh, yes, my lord.
Questions you don't want to answer.
Sorry, my lord. I have
Somehow, without ignoring all our questions, ignoring all things, we should simply pass a final order according to you.
No, sorry.
No need to answer questions from the court.
No. I have little amount, my lord. I have very small amount in the bank account.
Should we write small amount? What a small amount is 10 rupees, 5 rupees, 5,000 rupees. What is small amount?
Maybe 50 lakhs, 30 lakhs. Also.
Maybe. You don't know that.
No, I don't know because
nothing. If you don't know, then we can't also. We simply say counsel is unable to answer any question because he says he doesn't know.
Let it come on Monday. I'll take instruction from.
It's very sad, sir. The minute the court starts asking questions,
I'm sorry, my lord.
Either we should simply allow whatever you say.
No,
we should not ask any questions.
Yes, my lord.
How is that possible, sir? How is that possible?
Your lordship, may kindly. I will take instruction from my client from one.
Your chartered accountant can't answer a simple question. What is the bank balance in your client's account? That your chartered accountant cannot answer today. I find that very
Next week I will answer. I'll take instruction from the client and answer.
What is instruction, sir?
How much balance as on today lying in the bank?
Without this, you have drafted this whole petition. Without this basic information, you've drafted the whole petition and you want to stay. Complete blanket stay.
No blanket stay, my lord. With the next week, any day, I will come with preparation.
At the request of answer for the petitioner list on.
I did the balance in that.
21st March.
Item 27.
My lord, 21st March.
21st March. Item 27.
Till then, my lord, no correspondence.
Call it.
Item 27.
May I please, your lord. 27 is an income tax appeal, my lord.
All right. Counsel the appellant states that the appeal has been rendered infructuous. It is disposed of as such. Right.
Item 28.
28, I have received the Parawai's commercial loss. Grant me short adjournment. In the meantime, I will file the count.
No. Why? Adjournment for what?
To file the count.
No. This is a 2016 matter, sir.
Yes.
What is the case? What?
Stepping of payments of that of a judicial officer, of the junior matter, stepping of the payment. Notice was issued matters 11/1/2018 to file counter.
Again, time granted in 2017.
Yes.
Twice. Then 2018.
Last listed in 2018.
Only adjournments, sir. Only 5 adjournments for grant filing counter.
Last chance, Your Lordship.
He was 56 years in 2016. So now he's retired.
No, he's retired. He's retired.
Hmm. Let's come to the rejection order, sir. Annexure 9.
Annexure 9.
Ah.
May I read it, Mills?
Yes, please.
Stepping up pay of Sri Rajendra Paningrai, OSS, Judge Family Court, Bhuvanipatna, with that of his junior, Sri Manas Kumar Misra, OSS, Additional Special Judge, Vigilance, Bhubaneswar. In inviting a reference to your letter dated 4637 dated 16/5/2015 on the caption subject, I am directed to say that Sri Rajendra Paningrai joined in the cadre of District Judge on promotion on 31/8/2013. He has not exercised option at the time of his fixation of pay in the promotional post under Rule 74D and 74B of OSC, as required in Finance Department Memo number 2098. So his pay was fixed of 57,600 in the scale of pay of 51,550. We managed to increment 1230 and 58930, 1380 and such with effect from 31/8/2013 under Rule 74B SSC Home Department Office order dated such under 29/3/2014. But Sri Manas Kumar Misra, Additional Special Judge Vigilance, joined in the cadre of District Judge on promotion on 17/7/2013 and opted to continue in the lower scale up to his date of increment, that is 1/11/2013, and as such the pay was fixed on 58,930 in the scale of pay of 51,500, that is such and such on 1/11/2013 under Rule 74D and Rule 74B of Orissa Service Code by the Home Department Office Order number, that is such on 24/6/2014, consequent upon exercising option by him. Since the anomaly arises due to the exercise of option of Sri Manas Kumar Misra, who is junior to Mr. Rajendra Kumar Paningrai, Bhavanipatna, the stepping of pay of Sri Rajendra Kumar Paningrai is not admissible as per Finance Department Memo number such and such dated 8/4.
What is this, sir? Try and explain to me. If the junior exercises an option to go to continue in the lower scale of pay, why should the senior suffer? I mean, why should the senior not get his stepping up of pay?
Well, here in this case, that is my case. Case is that we are not, this what they are referring to, they are referring to OSRP rule matters is applicable to the state government. I have given that kind of a glance to the resolution in Annex 3. That is the resolution basing upon which the district judges and all other judicial officers have been given that scale of pay. That does not prescribe any stepping matters provision. And whatever circular they are relying upon, that is in respect of OSRP rule matter, that is in Annex 6. That has no application in respect of Annex 3 matters. They are referring to Annex 6 matters. That should have been referred to my lord's law department for consultation.
No, just see 4 in that. Maybe that is applicable. Page 58.
Page 58 minutes. Page 58 minutes.
No. Page 58.
Page 58 minutes.
Serial number 4.
4 minutes. Yes, minutes. That is in respect of ORSP rule 2008 minutes. That is not applicable to judicial officers. That panel kindly have a glance to page 57, the subject, clarification of Odisha revised scale of pay rule 2008. That is not up. I've given that kind of a glance to that panel. That kindly have a glance to page minus 24. The ORSP rule minus that is excludes that judicial officers.
No. Then what is the rule applicable to judicial officers?
Judicial officers I have given in minus annexer. That is annexer 3 minus at page 45.
No, but this doesn't include family courts and all.
Well, yes, all minus because all the family the district judges minus that is in the same cadre they are posted as family court judges. All that being these postings are being made by the Honorable High Court minors. And they are in the cadre itself minus what the clause minus kind of a glance to page 48 para 4 minors. Judicial officers includes district judge selection grade, district judge superintendent grade, district judge entry level also. But these minors so far as this judicial officers rule that pay fixation rule 2010 and kindly with a comparison with that of the minors page 24 that ORSP rule minors that excludes clause Roman 6 minors Roman 7 that excludes Odisha Judicial Superior Service Rule 1963, 1994 and all these minors. All judicial officers are excluded from the ORSP rule. They are extended benefit under Annex 3. That is minors knows that is on the basis of the Justice Padmanabhan committee and all this. So that is how the judicial officers that they are following a different procedure minors. And their fixations are in a different notification. That notification is made by law department. This rule is made by finance department.
No, actually when the time for exercising the option arose, your junior exercised his option to continue in the lower scale of pay. So in fact, he got a lower
What
scale
they have
on
done
promotion.
is, there is no such provision in so far Annex 3 is concerned. What they have done is, they probably given this benefit, they have, this man has, because of this state government, Bhubaneswar, somebody suggested and is given that option. This option, where is, there is no such provision of giving any option. There is no such provision in Annex 3. Kindly have a glance to minors Annexer 2. Annexer 2, first minus page 24. Then minors option in respect of all this in paragraph page 29, page 6, para 6. These provision are not there, minors. But right or wrong, he has given an option. That option was acted upon, and this he was extended that benefit.
No, option provision is as per the finance department memorandum dated 21/6/1988. That minors can get it.
Then minors this
first paragraph.
Then minors that committee minors super that committee judicial SETI committee and that Padmanabhan committee are not there. All these have come subsequent. So 88 rule 88 notification also does not apply. Because these minors knows that SETI on Supreme Court appointed Justice SETI committee and thereafter minors the Padmanabhan committee fitment upon all these things, and that is what Annex 10 was separate in the past a separate proceeding in a judicial order minors by the law department. All judicial officers are guided under law department notification. Resolution minors in Annex 3.
Was this option made available to this petitioner? Because he says no such option was given to him, whereas option was given to his subordinate.
No, he has to avail it.
No. Was it given? He says there was no such option, no question of any such option. Here in your order, you're trying to say he has not exercised option at the time of fixation of pay.
Yes.
Never asked for that option.
No. Was he offered? Was he told that he has to exercise that option? That's the question.
That is not there.
No, he was never offered.
If he was never given that option, where's the question of denying him the stepping up only because his junior exercised the option and he did not?
That notification is relevant whether it is required or not. But he has to give suo motu while availing the promotion, while joining the promotional
No,
post.
no, suo motu, is that system?
Is that
Somebody should know that he has to give an option, right?
that notification is relevant, that 88 notification.
No, no. And how can he control whether his junior is going to give an option or not? He cannot control that.
This notification can throw some light. It is 88 notification.
No, thereafter.
21,688.
ATT have lost its relevancy, my lords, in view of the fact that my lords, Justice Padmanabhan committee report has come at a latter part, and thereafter, my lords, the committee report, sorry, Justice Shetty committee, my lords, thereafter Padmanabhan committee
questions the very applicability of the Finance Department clarification dated 8th April 2010 and the earlier Finance Department OM dated 21st June 1988. So according to him, the issue regarding stepping up of pay of judicial officers is governed by the Law Department resolution dated 2nd August 2010. Paragraph. An affidavit will be filed by the opposite parties specific to the above issue, enclosing the copy of the Finance Department OM dated 21st June 1988. The affidavit will be filed positively on or before 2nd May 2022 with an advance copy to counsel for the petitioner. List on 27th June.
Item number 29.
29, my lord. I am in VC, my lord. The PIL matter. The petitioners at the villagers of village Saleswar in the district of Khurda. And there is a small approach road over an area of 3 decimal, which is traditionally used by the villagers to go to their agricultural land.
The same question, sir, which we've been asking others. Please come to Annexure 5 series.
Prior to that, my lord, Annexure 4 kindly have a glance. Annexure 4.
So that is a 2017 letter.
At page 17, my lord, kindly have a glance just.
So your representation.
It was forwarded in Annexure 4, my lord, page 17.
That is a 2017 letter, sir. Annexure 4 is dated 29th July 2017.
17, my lord.
Come to Annexure 5.
Annexure 5 in the year 2020, my lord.
That Annexure.
I have not acknowledged.
Giving up Annexure 5?
On the basis of Annexure 4, if it will be solved, then I have.
No.
On the basis of Annexure 4, if the government will take steps, the opposite party number will take step. Last vote 1 para. This traditional road is not.
More than 4 years old, sir.
Yes, my lord. Yes.
Representation, Mr.
Yes, my lord.
Yes, my lord. This is 2017.
But
But
when
this
it happened,
representation is Annexure 5 to the collector.
Annexure
of
5, I have not
2014.
acknowledged.
happened on this. You asked the principal secretary.
There is no acknowledgement of this.
No, my lord. There is no
29 July.
acknowledgement.
Yes.
This is the minister's letter, no?
No, 16th September is the collector's report.
Private secretary
Page
to
19.
Honorable Minister. The last vote
The
1
DK Manthi
para.
states that he will seek instructions on the action taken on the letter from the Minister for Revenue and Disaster Management dated 29 July 2017. And his request list on 4th May.
Hearing item 30. Item number 30. Supplementary list item number 30.
These 5 income tax appeals, identical questions are involved, my lord.
Right.
Your lordship may take up 24 of 2009.
All right. Power profit. ATIA. Yes, yes, Mr. Man. What happened to him? It's gone off.
My lord. I'm sorry, my lord. I got disconnected, my lord. My lord, in this case, the short question that is involved is, my lord, whether the appellant is entitled for deduction under section 80IA, subsection 4, clause 4, Roman 4 of the Income Tax Act towards interest derived from interest income. For that, your lordship may kindly turn to page 6 of my appeal memo, my lord. I have clarified what is the income. Paragraph 12, your lordship.
Yes.
Lordship. May I read, madam?
Yes.
That during the assessment proceeding, the appellate submitted that the income, whether from receipt of rent or electricity charges, sundry receipts or sale of scrap or interest income from employees, etc., are outcome of the only business of generation and distribution of power of the appellate company, because the appellant's only source of income is from business of generation of power. The appellant further submitted that it has taken various loans for operation on which interest is being paid. The appellant manages its funds generated from business of power generation by making short-term deposits with banks so as to meet installments on due dates. It was submitted by the appellant that the putting money in short-term deposits was a business compulsion, and therefore interest income from the said short-term deposits was part of the profits derived by the appellant company from the business of generation and distribution of the power, and is eligible for reduction under section 80IA of the Income Tax Act. May I take your lordship to section 80IA? What does 80IA provide? Your lordship?
Yes.
Subsection 1, where the gross total income of an assessee includes any profit and gains derived by an undertaking or an enterprise from any business referred to in subsection 4, such business being referred as so and so, there shall be, in accordance with the subject to the provisions of the, be allowed in computing the total income of the assessee deduction of an amount equal to 100% of the profit and gains derived from such business or for 10 consecutive assessment years. Now, thereafter, your lordship may come to subsection 4, Roman 4.
Yes.
An undertaking which the appellate is covered under this, my lord, is set up in any part of India for generation and distribution of power, if it begins to generate power at any time during the period beginning on the first day of April 1993 and ending on 31st day of March 2011. The appellant started its business in the year 1996-97. Now, your lordship may come to the ordering portion of the finding given by the tribunal. And at page 75, your lordship, my contention is the appellant is there. May I read, my lord, paragraph 9, my lord.
Yes.
Before us, the learned AR for the SSC contended that their income of 24 crores or consisted of interest from customers amounting to 9 crore, interest from non-customers amounting to 14 crore, and interest items so and so. It was further claimed by him that total interest earned during the relevant year was 24 crore 92 lakhs 28,750, whereas total interest paid is 40 crore and not. It was therefore claimed by him that deduction under section 80IA of the Act should have been allowed in view of the Honorable Judicial High Court's decision in Tata Spon so and so, though specifically contended by him that interest received on delayed payment of sale proceeds has to be considered as income derived by individual industrial undertaking from the eligible business. Now the finding is that your lordship may find at paragraph 11. May I please, your lordship?
Yes.
We have heard both parties and perused the record. At the outset, we would like to state that details of other income have been provided by the appellant in ground number 5 from the same. It is absolutely clear. 14 crores amount was amount of interest shown on short-term deposit in bank, and 9,000 was interest from Gridco bonds, which was delayed payment bonds, my lord, given by Gridco, which were received by the SSC in lieu of unpaid energy bills. Thus, the contention of learned AR for the SSC that 9 crore was interest received for delayed payment of power bills by Gridco is not borne out of facts on record. These are the findings which are totally incorrect, my lord. The SSC has not been able to show any nexus between impugned interest received by it with the interest payments. Thus, we find that the disputed issue squarely covered by decision of the Honorable Apex Court in Pandian Chemicals, which was followed by Honorable Jurisdiction High Court in Tata Spon so and so, so and so. So my contention is, the sole contention is, the appellant has no other source of income other than the from generation of power, and these interests are derived during the course of the business only, my lord. So it is squarely covered under 80IA subsection 4 clause 4 of the Income Tax Act, and deduction should have been allowed, my lord.
Yes, who's for the?
You see the section 8A, Lord, here's not subclass 4 of 8IA.
80IA.
Subclass 4.
Yes.
That is the lordship may see that refer to subsection 4. If it's come within the section 4, then you'll have the 80IA deduction. This says, Lord, Roman I, any enterprise carry on business or developing or operating or maintaining or developing, operating, maintaining any infrastructure facility which falls in the following condition. Whether this is an infrastructure developing what he has received.
No, your lordship is the subsection 4, clause 4, Roman 4, an undertaking which, I don't know what my learned senior is.
An undertaking which is set up in any part of India for generation or generation and distribution of power.
Yes, but the opening word is the enterprise carrying on business and operating an infrastructure facility which falls within following condition. Whether
So this is an infrastructure facility, but it is set up for generation of electricity.
Yes. But the section itself say 81.
But you can't read it in isolation, sir. You have to continuously read it.
Yes, but the opening word is the section applies to.
No, that is not even the ground on which you are denying. You're only denying it. You're saying interest earned and interest spent, there is no nexus. Yes. And therefore, you're not allowing netting. You're not saying because you're not an infrastructure as defined under this. That's not the ground on which you're denying it.
See the appellate order.
Your DR's argument was that there is no nexus.
Yes, but that is there.
There's no other grounds argued.
Relying the order of the authority below and submitted as not a case of interest received from the customer. Paragraph 10.
Yes.
Above the finding. As such, the customer issued bond to the SSC in the earlier previous year on which interest was received by the SSC.
Bond is in lieu of payment, sir. This man does no other business.
Yes, only Milord, there is no dispute at all, Milord.
Ah.
There is the fact remain, Milord, he is doing the same business, but it is contended him that the case law cited by the land heir of the asset not applicable, it is further submitted by him that netting of interest can be done only if nexus is provided by the assessee.
Gridco has no payment, doesn't have money to pay. It's issuing bonds on which the assessee earns interest.
Therefore, Milord, the but however, he is claiming the exemption under the 80 IA.
No. We'll reserve orders. Orders reserved. We'll allow it.
I know. Deeply
All
obsessed.
All right. Okay.
So the requisite may be accepted.
Okay, the requisites file be accepted for the next returnable date, that is 22nd April. All right.
Your Lordship, I am basically now in abroad. It may be kept on 28th, after 28th of March.
We have kept it for 22nd April.
Your Lordship. Okay. Obliged.
Item number 4.
Item number 4, my lord. Item 4.
Item number 4 is an application under section 11 of Arbitration and Conciliation Act for appointment of arbitrators.
Where's the arbitration clause, sir?
This is in the agreement, page number, Lordship may kindly see page 13, clause number 23.
Page
13, clause number 23.
There's no venue clause here.
Clause 23, in case of dispute arising between the parties, the matter may be referred to.
No, there's no venue issue, is it? All right, just a notice returnable 29th April.
Any short date maybe?
Item number
Madam,
5.
any short date in item number 4?
No, 29th, you'll need that time. Yes.
Item number 5.
Public.
May I please, Your Lord. Page 96, clause 29 is the arbitration clause and venue is cut off, my Lord. Page 96, Your Lord.
Who's for the opposite party?
My lord,
You're objecting?
no, but that may not be recorded.
All right. Having heard learned counsel of the parties and leaving all contentions and merits open to be adjudicated in the arbitration proceedings, the court appoints. What's the claim?
My Lord, more than 10 crores, my Lord. If my learned senior not object, my Lord, maybe Justice BP Das. If he has no objection.
No, Justice BP Das, as the sole arbitrator to adjudicate the disputes between the parties, including the claims and counterclaims. The arbitration will take place under the aegis of the arbitration center. All right.
Item number 6.
Item number 6. I pray Lordship may call it on 11th or 25th, or by file the counter positively by Monday or Tuesday.
Counsel for the opposite party assures the court the counterclaims will be positively filed on or before 14th March 2020. Adjourned before the next date, list on 29th April.
I am for the petition.
All right. All right.
Item number 7.
My lord, I am for the petitioner, my lord, here. This for appointment of the arbitrator, my lord. The opposite party has entered appearance and filed his counter affidavit, my lord. My lord, the agreement clause, my lord, provides for, my lord, adjudication of the dispute by way of arbitration, my lord. It is at page 34, my lord.
Who's for the other side?
My lord, Mr. Prabhu is there, my brother is there.
All right.
I'm appearing.
Yes.
If he doesn't mind, my lord, to appoint arbitrator, your consensus arbitrator can be appointed.
Yes, yes, Mr. Bera.
My lord, Mr. SP Mishra, I can suggest, my lord.
All right.
My lord, sir, I have objection to the petition in view of the fact that the clause and the agreement has expired long back, and this arbitration clause is. I admit that the law is well settled that the arbitration clause is a separate company.
Yeah.
But my lord, here is a peculiar case, my lords. After I terminated the I terminated the agreement to sell, and my lord, he also agreed to the proposal of termination. And when we were supposed to execute the cancellation deed, he did not turn up. Then he started filing criminal cases against me, and the criminal cases are pending. Then notices were issued, and this arbitration proceeding is in the conduct of the party.
No. If you're willing to go for mediation, go for it.
My lords, if my learned senior agrees, mediation can be explored.
You want to try mediation first, sir?
Yes, my lords. I would be.
No issue.
All right. Both parties agree to explore the possibility of settling their disputes through mediation in the first instance. They will appear in the mediation center at 3:30 p.m. on 16th March.
My lord, in the last week, because my daughter examination is there at Bangalore, I have to take her, my lord. Can it be 21st, my lord?
All right, 21st March at
My
3:30.
lord, the mediator will be, my lord, may I pray, Mr. SP Mishra will
Yeah,
be.
Mr. SP Mishra, learned senior counsel, is requested to mediate, act as the mediator. The mediation will take place at the mediation center. Full stop. List on 8th April.
Obliged, my lord.
All right.
Item number 8.
My lord, item 8, I am here, my lord.
I'm appealing for the number 2 and 3. I pray, man, 7-8 days time to file the counter to this.
Last opportunity to the opposite parties, 2 and 3 to file the reply.
May I pray one thing, my lord? If my lord permits, it can be settled in mediation, as your lordship earlier. Let us have a try.
We are serious dispute. Let me file objection to it, man.
Let us try, my lord. If my learned friend agrees, let us try for a mediation.
No harm in trying, sir.
My lord, let me sir file objection.
If you file a reply, then there's no mediation. Try mediation, then file a reply.
Because we are serious dispute in this matter, that's why I specifically instructed to file objection to this matter.
My client is intact with the instruction given by his clients. Stick
No,
to
the
his.
only thing is mediation becomes a non-starter if the parties don't agree. So that's the whole problem.
Yes, your lordship.
All right. Counsel for the opposite parties 2 and 3. Prays and is granted 2 weeks time to file reply. Rejoined if any.
Stop date, my lord.
22nd April is the shortest, sir.
Obliged.
All right.
Obliged.
All right.
Item number 9.
My lord, 9, 10 and 11, my lord, your lordship last occasion issued notice to the opposite party. The tracking report has.
I have been instructed just to appear in the 9, 10, 11. Let me 1 month time.
All right. Counsel to the opposite party seeks and is granted 4 weeks to file a reply. Rejoined the next date. This on 6th May, sir.
6th May. Obliged.
Item number 12.
Please, Your Lordship. Not I appear for the opposite party 1. The pleadings are completed in this.
Are you objecting?
Lord, the arbitrator has already been appointed. As Your Lordship's last direction, they are proceeding ahead, but the final award is not passed as per Your Lordship's order.
Who's for the other side?
And
You are
we
for
had-
the opposite side.
On the opposite side.
Who's
We
for
had
the
given
petitioner?
the
Mr.
Zoom
Rao.
link. Mr. Rao was there.
Yes, Mr.
my lord,
Rao.
I'm there. Yes, my lord, I'm there. My lord. I'm sorry. My lord, here is a case, my lord, where I have received a notice recalling the loan on in Annexer 2.
Why didn't you agree to another arbitrator?
My lord?
Why didn't you agree to another arbitrator?
Lord, it's already there, so that the scope of 11.6, my lord, is restricted.
Obviously, he's not enthused. He's not confident about your arbitrator. That's why he's come here. It's not an agreement, mutual agreement. It's not an arbitrator appointed by mutual agreement.
My lord, so here is a case, my lord, where the loan is admitted and only refacement. So if your lordships will refer the matter for mediation center also, it can be settled.
Mediation, if he can update the account, my lord, will withdraw the arbitration proceeding.
Oh,
We
I
are
see.
interested in money, my lord, nothing
All
else.
right. But they have now recalled the loan. I am willing to pay the EMIs. I have in fact deposited. also.
So he's saying if you are able to regularize the loan account, the
Yes,
whole.
ma'am. I will be able to do that. So let it be referred to mediation center so that it can be settled how much I
All
will
right.
pay.
Parties agree to explore the possibility of settling the dispute through mediation. They will appear before in the mediation center at 3:30 p.m. on 23rd March, sir.
23rd March.
Your lordship will appoint somebody as mediator.
Mediation center will go to small amount, actually.
Yes. Yes.
Somebody will be there, sir, in the mediation.
Yes. Absolutely. No problem.
Report of
23rd
mediation
March.
be placed for the court on the next date. 22nd April, sir.
Obliged.
Item number 13.
13, my lords, on 28th of January, my lords was pleased to issue notice.
Yes, we are appearing for opposite party. Today we are filing our appearance. My lord, may grant some time, we'll file our reply.
All right. Counsel to the opposite party seeks and is granted 4 weeks to file reply. Adjourned for the next date. 6th May.
Item number 14.
With item number 14, my lord, I appear for the petitioner. With myself, Kishore Datta, my lord.
My lord,
appearing for the
let me
petitioner.
solve a
This is
copy of
a-
the same.
Who's for the
Yes,
yes, Mr. Pari?
Yes. Today I am entering appearance on behalf of railway, my lord. Let them serve a copy. They are filing application. It is a second time extension of the mandate. So railway also file a arbitration application. Let both the application will take next week, my lord, on 11th. Because next day
Copy has already been served. Copy has already been served.
All right, I'll collect from the department officer.
28th of January, copy has been served. As per the honorable court.
All right, because our railway council might have received, we will take the copy. There is no issue.
Mr. DK sir has received the copy.
Yes, now the panel has been sent you to come to you. We'll take care of in that part.
What is your application number? What is the
Our
railway?
application, today it was filed e-application number, that is ER oblique ODHC 01 oblique 00318 of 2022 mile.
And
Just
you'll have to
today
get
it
it
was
numbered.
filed by
That's the diary number. You'll have to get it numbered, sir.
e-filing number. ARBN number was
All
not.
right. You say list along with, at the request of Mr. P.K. Padi, learned ASGI, who appears for the railways, list along with the application stated have been filed by the railways on 11th March.
No, 11th March. Man.
All right, 11th March.
Lordship may reflect Mr. Devasi Satpathy who is appearing in this case.
All right.
No, the copy may be, the railways application may be served upon us.
Definitely, we will file, yes. Just local councils may give in, Mr. Datta may give the reference of this, we can file the mail. You can send it to mail by.
Very, very.
All right.
I'm grateful.
All right. All right.
Supplementary list for orders item number 1.
This is Panigrahi.
Lordship.
No. So no notice went to this MCL. The authority, opposite party number 6 in the writ petition, no notice was issued to them.
Yeah, we can issue notice to the opposite party.
No. So the review petition has been filed by them, therefore. Mr. Nadkarni is appearing.
Yes,
Yes.
The original respondent MCL, now the petitioner before your lordships.
Correct.
But I think inadvertently the court did not issue notice and went by the statement made by the
That's
government.
what. We just noticed that.
Yeah.
So we'll issue notice in this review petition so that the original writ petitioner is present.
Yes.
All right. Yes, please.
Mr. Das, are you appearing?
Yes, I am appearing also, my lords, for MCL.
Oh,
He's
for
appearing
MCL.
along with me.
All right. We say notice in both these petitions. Notice additionally be served through the counsel appearing for the original writ petitioners, returnable on the next date. We'll give some time. We'll have it on 8th April.
Lordship, please.
All right.
We have a prayer, my lords, there now issued a demand notice to ask for paying under the.
They say the judgment may not be acted upon in the meantime.
All right. You say in the meanwhile, the judgment of the review shall remain stayed.
I do.
All right, Justice Panigrahi.
Thank you, sir.
All right.